Hello, thank you for joining Six Sigma for Paralegals. This particular session is going to discuss how to apply the Six Sigma methodology to legal technology processes. Now, this course will specifically focus on how to improve paralegal productivity and efficiency by utilizing the quality improvement and the error reduction principles of Six Sigma, because that's really what's at the core of Six Sigma. It's a quality improvement program, per se, and applying it correctly will allow you to reduce errors. It will also allow you to increase your productivity. Now, this course will specifically address methods to incorporate the Six Sigma methodology into the technological aspects of the various functions that make up the legal process. So it's important to be able to start with some basics about Six Sigma, which is what we're going to do, because you don't have to understand this entire Six Sigma body of knowledge in order to apply it to your job or to apply it within your organization. This particular session will guide you through how to apply it. That's a big chunk of Six Sigma. When you're using Six Sigma and you're developing a program, it takes you through the steps of creating the project that you're going to work on, and applying it, how to apply it, how to measure. It takes you through all those steps, but this particular session does that for you. So you don't have to really understand the little pieces and the detailed parts about Six Sigma in order to use it, because that's what this session is actually doing, that work for you. And all the other sessions, like on legal research and legal customer service, is what has been done for you already, is a particular aspect of the legal process where errors typically occur has been selected, and then through the particular course or the program, it shows you how to go about applying it to your particular job or your career. Because Six Sigma, if you've ever heard of it before, is very numerical and statistically driven. And so sometimes it could be really intimidating for people to want to apply it, but you don't have to be a statistician or a mathematician in order to be able to derive the benefits from it. And that's what we're going to do in this particular session, is to give you the information, the tools to be able to apply it, to be able to improve your efficiency as a paralegal. Now, we're going to discuss various aspects of the legal process and how to apply Six Sigma within those particular processes. We're going to discuss how to use Six Sigma to measure and track legal technological efficiency. We're going to do a brief examination of the future of law and why applying Six Sigma within the technological processes in a legal organization, why it's important now and why it's going to continue to be important based off of where the future of law will be. We'll go on to discuss some common legal process errors. Then we're going to discuss e-courtrooms, e-filing, usage and consideration, Eservice, EDiscovery, and how to apply Six Sigma within these particular aspects of a legal process. And at the end, we're going to go over a case study of satellite testimony. So, where will technology in the legal field be in 10 years? Right now, you're already seeing changes that are going on in the legal field as far as technology is concerned. Now I have more courts that are allowing electronic filing. You also have courts that are using e-courtrooms to where everything, testimony and the whole trial process is being done with the use of e-courtrooms. Then you have discovery, where before you were using mostly gathering paper documents and physical information, where now with the increase of social media sites and tablets and cell phones, texting and emails, now a lot of discovery is done through the use of some specific systems and practices related to extracting that information, that evidence, or whatever, you know, is pertaining to the case from electronic modes. Then you also have client relations. Now you have virtual law firms where they're actually conducting consultations and meetings over the phone and over the internet. You also have legal documents that are being prepared online. You have companies like LegalZoom and Rocket Matter, where you can have a document filed completely online without ever needing to meet with someone in person. So these are just some of the areas where you see that technology is actually changing the way that law is being handled, in particular aspects of law is being conducted. E-courtrooms, filing, discovery, client relations, pretty much every aspect of the legal process is being affected by technology. So then if you want to fast forward 10 years and consider where technology's usage will be within these areas, but then other areas also, especially with e-discovery. E-discovery is a huge area where technology has, or discovery. Now e-discovery is that aspect of discovery that's specifically dealing with technology, you know, totally different, pretty much branch of discovery, where now there's no really set rules dealing with the process, but courts and judges and lawyers understand that there are some specific issues when dealing with electronic discovery. One is the cost, because before, when dealing with just paper discovery, you didn't really need a specialist in order to deal with that. It was paper. Well, when you're dealing with e-discovery, there's the person that's dealing with that aspect of discovery really has to have some type of special knowledge of different formats, how to extract information from systems without corrupting it, how to preserve information. Chain of custody is really important as far as preserving the evidence while it's going through different hands. And when you're dealing with e-discovery, a lot of times companies, firms, legal organizations are using the expertise of outside vendors. And so then another issue comes into play, because the evidence is now going through someone else's hand. So you have all these issues that are, you know, evolving and creating some specific scenarios regarding discovery. So now there are no rules regarding standard practices of e-discovery. Well, 10 years from now, because of the issues related to e-discovery, cost being one, because specialists being needing to be used, the volume of information that can be obtained in these different electronic devices, and that affecting cost. Practitioners, legal lawyers, and judges are understanding that there's a impact on the ability for litigants to be able to successfully handle cases because of the cost. So 10 years from now, e-discovery, specifically e-discovery, is probably going to look totally different than e-courtrooms, because with budget cuts and court staff being cut down, e-courtrooms may be the norm. Electronic, where the different aspects of a trial and a case is being handled electronically. So when we're thinking of Six Sigma, and how it even relates to this as far as law from the future, because technology has, even humans, we have room for error, but technology, for some reason, when people are using technology, there's always that fear that there's going to be something that's missed because the human element has been removed. So with Six Sigma, when there's the different tools and processes that are implemented and infused within these specific areas, it will reduce those risks, and not just reduce them, be able to provide proof that these particular methods that are being employed using technology, that they're error proof, or the error has been reduced to the smallest part. And that allows lawyers, judges, and other individuals involved in the legal process to have a comfort level when dealing with electronic aspects of the legal process. And so that's where Six Sigma comes in, because it allows for a systematic and consistent way to be able to address errors to reduce those particular errors. And in the future, it's going to be more so important, when you're dealing with e-courtrooms and e-filing and e-discovery, and even communications with clients electronically. So what exactly is Six Sigma? It's not a term or a system that was created specifically for this particular course or program. It wasn't even actually created specifically for the legal field. It did not originate there. Six Sigma is a statistical term, and it actually represents the measure of defects or errors in a process. And at its core, Six Sigma is about quality, but it goes beyond an organization's definition of quality, and it views quality from the perspective of the customer. The reason why that's important, especially in legal organizations, because what happens a lot in legal organizations is the measurement of quality is usually defined by filing deadlines being met, how many customers are being brought in, billable hour quotas, which I think that's done a lot, where quality and the success per se of that particular firm and the quality of their service and that quality of a particular let's say paralegal or staff member is determined based off of them meeting some billable hour quotas, which totally leaves the customer out of the loop of this whole process of providing them legal services. So with the use of Six Sigma, it places the customer back in the loop. It allows the customer's voice pretty much to be heard. And this is not just a nicety, something that provides a way for a firm to be able to compete with another firm by saying that they're very customer oriented, which is, unusual for a firm to say, so it would provide them some type of competitive advantage. It's a rule of professional conduct. It's an obligation that a firm, an attorney, paralegal working on a case has to a customer. It's saying that the customer has a right to quality, to having quality service. So then the definition of quality in that aspect has to be analyzed. Does quality just mean that once a client retains an attorney or firm, that when they came to the firm and asked for, let's say a bankruptcy to be filed from, that the bankruptcy was filed? But the client's been calling, the client's been asking specific questions, the client has actually asked how to address the specific aspect of the bankruptcy, and it's never addressed. So although the bankruptcy was filed, did the client get what they wanted? Were they kept in a loop, which is actually an obligation? So this is where Six Sigma comes in, because it goes beyond just measuring quality based off of meeting billable hour quotas. It goes beyond measuring quality and success per se, based off of, you know, the success of the firm or success of the particular individual in that position, and then being evaluated based off of internal factors, and leaving the customer totally out of it. And so that's why using Six Sigma is really important, just in legal organizations overall, but specifically in legal and applying it to the technological aspects of the legal process, which really technology affects, which we just kind of went over a little while ago, is touching every aspect of legal processes, touching on the courtroom, the filing, the communication with the client. It's touching all of these, every discovery is touching all of these areas. So when applying Six Sigma to legal technology, you're really applying it to every area within a legal process or a case. Now, this is a quote by the General Electric CEO, Jack Welch, and he's often touted as the most successful CEO in history. And Six Sigma was applied at GE. It was applied successfully. And this is a statement that he made regarding Six Sigma. And quote, "So Six Sigma is a technique which you can train your people in to reduce variation. Variation is evil. And once you reduce variation, your costs are improved dramatically, and your market share gains are enormous because people get what they want when they want it." Now, most, paralegals, partners, legal administrators, they're not going to be, may not be that candid as Mr. Welch about errors, and as he puts it, them being evil, but they will admit that variations from things like filing deadlines, court rules, and client expectation is a serious problem, and it can't be ignored. So Six Sigma is really that radiation needed to eliminate what, I won't use the term evil like Mr. Welch, but I'll use the term cancerous. It's a cancer. Because a cancer is something that it's not just looked at as a problem. It's looked at like this thing is a serious, not just problem, but dilemma, in the sense where it's affecting so many aspects of the health of that particular individual, and it can't be dealt with in a casual manner. When you think of something being a problem or an issue, sometimes it's just addressed in a casual manner. But when you think of something in a sense of it being cancerous, how is cancer handled? Cancer is handled very aggressively. It's handled with radiation. And that's how legal process errors have to be addressed. They have to be addressed as if they are cancers, and they have to be addressed aggressively. And that's why Six Sigma is so important, because it's an aggressive method of dealing with legal process errors, and not just saying, okay, we're going to improve this in our firm and in my job, because you can apply it in your specific job without even being implemented in your firm or your organization. You may notice you're not meeting your billable hour quotas. You may notice that during your reviews, there's particular things that keep cropping up over and over again. Well, that's a cancer. That's something that needs to be attacked and addressed aggressively, and that's where Six Sigma comes in. This aggressive method of being able to address errors, issues within, in this specific case, we're talking about legal technology. So let's talk about what those errors are. What are some of those specific errors within a legal technology process? And how would you go about applying Six Sigma? Because I mentioned before that you don't even have to know. I gave you a definition, so now you know what it is. It's a quality improvement process, system that you can use. You know what it is now. So you don't have to, again, be a statistical genius or a mathematician to be able to apply it, even though the term itself is derived from statistics. You just have to know how to apply it. So here's how you can apply it. Determine a classification system for errors. You can start off by, I mentioned before, review, and noticing that something is cropping up over and over again. So now you've pinpointed what the error is because it's something that's coming up in a review. And based off of that, determine a class of, and also you may notice that there's something that's you're not able to get all of your filings done, or whatever the case may be, on your own. So you come up with the first step is to determine a classification system for the errors. And this is an example of a common method, which is to use 3 categories: critical errors, major errors, and minor errors. Classify errors within those particular categories. Critical, you starting off with something being critical, then major and minor, so it's categorized by the severity of it. And then client community. These are some examples of some errors and how to classify those particular errors, like client communication. Error within that particular process can be client complaints. Client complaints, that's an error. You zoned in on a particular issue, whatever that client complaint is. That's a problem. To get a complaint from a client is a problem if it has merit, especially if the complaint is being made to the bar, or if the complaint is being made through the use of filing a lawsuit. Case management, an error or errors that can come up in that particular process is missed deadlines and clerical errors. Just missing the deadlines, but let's say calculating the deadlines incorrectly. And then billing, errors in that particular process is working on non-value added functions, working on those clerical tasks that have you can bill for them. They have no value added as far as being able to bill clients back for them, but also not just being able to bill clients back, double billing clients, doing repeat work or working inefficiently, which is resulting in increased billings to clients. That's an error. That's a problem. That's non-value added because it's really not to be billed to the client because you or someone in your firm, if you're a manager, is inefficient. So those are all errors, and those are some specific errors within, again, client communication, case management, and billing. And you can classify these errors, again, into critical error, major error, minor. Use your own system. What it's doing is classifying them by severity, and you can determine that based off of its effect on something. A critical error, whatever terminology you want to use, is something that it's serious. It's going to affect something negatively. It's going to affect the outcome of a case, something like that. Major, it may. It's a major problem. It may have some type of effect on something. And then minor errors, it may not. It's probably just something that can be quickly fixed, but it may take you time. I mentioned before with the non-value added services, it could be something like you might have to go and pull up the case again because you didn't take notes and you don't know what you researched or whatever the case may be. So now that's an error. That's a problem because if you're duplicating your efforts, if you're billing the client for that, you're billing them twice. So that's a minor error if it's just happening, once or on a small scale. When you start dealing with it, on a larger level because there's some other issues going on, then they can jump up to becoming a major error. But you want to classify issues within categories, because when you do that, then it allows you to come up with a systematic method of being able to address these particular errors. And you may want to start, in your job, if you're applying it within your job, because again, it does not, the Six Sigma program per se does not have to be implemented in your firm or your organization for you to take advantage of its benefits. You may notice that on your reviews, there's certain things that are cropping up again, or you're having some issues of being able to get certain things done efficiently. So you yourself can categorize these errors into certain categories, and then by that start off by addressing the critical errors, or the most crucial errors first, then go down to major, then minor. So it gives you a systematic way to be able to address these particular errors without one becoming overwhelmed because you're trying to do everything at once, but also allows you to address the most serious issues first because they have the most serious impact. Now, these are some legal process errors as far as it relates to technology. We mentioned before billing, double billing. This can occur, as far as technology is concerned, when you're not keeping accurate track of your billable hours, what you worked on. You can implement a technology system in order to do that. Or if you're having issues with the system you're using, coming up with a different method. Confidentiality issues can occur within any legal process as far as it relates to, let's say, when you're emailing several people and you have a practice of hitting reply all when there's a number of people on the email, and you get in this practice, and let's say you're dealing with something that is confidential or privileged information, you're doing this reply all. That's a problem that can occur when using technology. Another example would be during the discovery process, not accurately locating confidential documents and that being handed over to opposing counsel or to the court. Errors can occur in the EDiscovery process. There could be errors in public record searches, failure to know or ascertain deadlines correctly, failure to calendar properly, inadequate conflict checks, security breaches, and then word processing errors. These are all errors that are specific to the legal process aspect of handling legal matters. And this is why it's important to be able to have a system to be able to address these. And these particular issues are common errors across the board as far as complaints that are being made and research being done as far as repeat errors or across the board errors that are going on within law firms overall and legal organizations overall, based on studies that are done by malpractice insurance providers and bar associations. Now, e-practice, I mentioned before that a lot of law firms have virtual law offices. And so when you have virtual law offices, or you're working a lot with technology in your particular job or your organization, these are just some specific areas where technology is being used in a law practice. Calendaring, case management, client communication, conflict checks, court presentations, discovery, docketing, docket automation or document automation, document management, like scanning and Bates numbering, filing and storing of the documents, legal research, and witness interviewing. So as you can see in a practice, even if it's not a virtual law office, a lot of firms use technology in all of these particular areas, and so therefore Six Sigma can be applied in order to reduce errors within these specific areas. Then you have e-courtrooms. You have courtroom technology. These are the different phases or different aspects of an electronic courtroom. You have the courtroom technology, and these are all areas where errors can come in at, especially because it's so new. If a person does not know how to use technology effectively, and different other issues may come into play. So Six Sigma can be applied to the use of e-courtrooms in a legal process or a specific legal matter. Courtroom technology is typically broken down into 3 levels. Level 1 is the simple to use and is inexpensive, so you may not really have that many errors on with level 1 courtroom technology, because it's whatever that technology is, it's common enough to where most legal practitioners know how to use it. Level 2, these are more costly systems or technology that's being used in a courtroom and typically require an expert. So with that, unless the firm is trying to operate this particular system or equipment on their own, then because of the use of an expert, the error in there is with using level 2 courtroom technology will be pretty much greatly reduced because of that factor, unless again the attorney or paralegal is new with using that particular system or that that equipment. Then level 3 is expensive technology, which is it's not funded by the court. So with that, again, if an expert is not being used, if a paralegal is being asked to use it, maybe specific technology is being used to be able to display some type of exhibit or whatever the case may be, and the paralegal is the one that's being asked to operate it. There's a huge possibility for errors to come in during that process. When I speak of errors, I'm not just talking about errors like typing something wrong or calendar errors. An error in this aspect, because we're talking about courtroom technology, could be not being able to display a technology or an exhibit, a presentation effectively, because of not knowing how to effectively use that particular piece of equipment. So that's an error. That's a problem. It could affect a jury member from being able to accurately see a visual, or for visual not to be even used at all, which would have a huge impact on the decision being made in a case. You also have discovery technology that's used in e-courtrooms. And you have pretrial technology. This is usually used with things like disclosures and equipment issues are addressed with pretrial technology. Then you have the actual trial technology, which deals with preliminary matters, testing, positioning of equipment, jury issues as far as, taking in consideration the ability for jurors to see exhibits, see information, because again, when you're using e-courtrooms, you're going to be relying on technology to be able to display or even to be able to play audio. So during the voir dire, questions need to be asked in order to uncover any maybe like hearing issues, any seeing issues, things like that in a regular courtroom would not need to be addressed. But because of the usage of technology to display exhibits and audio, those are things that need to be addressed. So it reduces errors, and an error in that sense would be a juror not being able to hear an audio that's being played because of the distance from that juror, or not being able to see a exhibit that's being presented because again some sight issues. So those are errors that can come up in e-courtrooms, and using Six Sigma allows you as a paralegal or your firm to be able to address these issues and reduce the likelihood or altogether eliminate them before they cause serious issues. And a serious issue with the aspect of using trial technology, again, if a juror or jurors are not able to hear audio that's being played for testimony or exhibits, then they're not going to be able to accurately make a decision in a case. Now, during EDiscovery, you can apply it to pretty much all the phases of EDiscovery. In EDiscovery, there are 5 different phases. You have the preservation and collection phase. You're collecting the evidence, the information, and keep in mind again, this is electronic information, electronic evidence, and processing phase. the analysis phase, the review phase, and the production phase. You know, there's you can learn more about the different EDiscovery phase. You can go to the Sedona conference, just Google that. They're a premier organization that deals with EDiscovery. You can also go to the website ediscovery.com if you want to learn more about EDiscovery and just kind of learn more about these different processes and what they actually address. And e-filing, you want to ensure that private information is redacted prior to filing. That's an error when information is private. Let's say, for example, in bankruptcies, you may have loan documents that have that need to be filed to be able to substantiate a claim that's being filed in that bankruptcy. And the supporting document, like the loan document, mortgage document, has identifying information on it. Well, that information will need to be redacted because that's private information, although the bankruptcy is public. It needs to be redacted before filing. Not redacting that information, not and exposing, again, private information, that's an error. So ensuring that private information is redacted is important. You know, when you're dealing with e-filing, you want to know be knowledgeable about the applicable court rules. You know, how do courts ask for things to be filed? Do you have to attach the exhibit or along with it? Is it separate? Just knowing that is important and will reduce errors when doing e-filing. Also, knowing the court filing deadlines as far as it relates to systems. Again, you're using a system, you're using an electronic system. So let's say, for instance, you have a deadline where all the documents have to be filed, let's say on the 15th. Well, the court, and you wait to the last minute of the court in order for it to be state or show that it's filed on that particular date. It may have a cutoff time, you know, let's say 2 o'clock, 3 o'clock. And if you're filing in different time zones, if you're in a firm or organization that file in different time zones, it's really important to keep that in mind, to know what the deadlines or those cutoff times are. And also to be aware of any court system upgrades that may be occurring. Because if you know, a lot of times courts, they'll publish and make it available when their regular upgrades occur. Like they may say, okay, a system upgrade every Wednesday at 3 o'clock on, so that no filings can be made, or every month, or what case may be. It's really important to know that, so that if you have filings that are need to be done on that date, then you can make other arrangements for the filing and getting it filed on time. Now, Eservice is being used more now, where people in cases can be served electronically. You had even one case where it was a major firm. They actually served someone through their social media site. So we talked earlier about the law practice of the future. Is that something that's going to be more acceptable in the norm? Because social media is such a common way of communicating, and it's an easy way actually of being able to locate people, where you may not be able to locate them in any other way, but being able to locate them on their Twitter or their Facebook or LinkedIn and all these other different social media sites. Is that going to be a norm in the future? So right now there are, different rules relating to e-service and when it's allowed. So it's important to research that, know when it is allowed, when it's not. So you're not using e-service in a jurisdiction that does not allow it. Then knowing the methods of serving electronically, like can it be done through fax? Can it be done through email? Can it be done through, if someone served through social media, is that going to be an acceptable form of service? Just knowing those applicable rules in your jurisdiction could reduce errors as far as serving someone incorrectly. These are some specific rules that address on the federal level e-service. You have the Federal Rules of Civil Procedure 5B, 6E, and 77. Then you have Federal Rules of Bankruptcy Procedure 9006 and 9022. Then you have Federal Rules of Criminal Procedure 49E. So, how do you track? I mentioned we talked about what Six Sigma is, different aspects of the legal process where technology impacts it, like e-filing, e-service, e-courtrooms, e-discovery, what those errors are in those particular processes. So now it's important to, and then categorizing, how to categorize errors. So now let's talk about how to measure and track technological efficiency, because again, Six Sigma is not just about finding problems. Okay, this is a problem. The goal is to be able to reduce and altogether eliminate that problem, that error. So you want to be able to have some method to be able to measure and track efficiency, because once you find the error, the goal is to come up with a method to be able to address it and improve it. So how are you able to measure that? Well, first you want to determine a time frame. When will you do this measurement? Is it going to be done every week? Is it going to be done at every month? Meaning, let's say you work on 50 cases and you want to be able to determine filing accuracy, as far as how many days before the filing deadline you're filing particular documents with the court. Are you going to do this, measure this by taking all the cases you worked on and filed with the court in a week, and from that determine how many were filed within, let's say, 5 days of the filing deadlines? Are you going to go by month? Are you going to go by year? How are you going to measure this? I wouldn't suggest doing it by year, because that's a long time to be able to come up with a method to reduce some errors that may not have been discovered in your preliminary determination of what errors were occurring in your particular job or your organization. But if you're dealing with something that is not a regular occurrence, a year may be feasible. But again, you want to determine a time frame, a week, a month, a year. Who will do the measurements? Are you doing this? If it's something that you're just implementing in your job, you'll be the person that's doing it. If you're a manager, are you going to do this because you're the manager? Or are you going to require each employee to do their own measuring and tracking as far as reporting, sending a report at the end of the week, end of the month? Then you have to know what you're measuring. Are you measuring cases? Are you taking a measurement of all cases handled overall, and from there breaking out and pulling out the errors within that process, or efficiency, how many the increase of timeliness? Are you just based off of complaints? What are you measuring? And then how will you measure improvement or progress? Are you going to use reporting capabilities and case management systems? You have specific systems that can be used, like Oracle Crystal Ball. You can use Excel spreadsheets and charts. How will you measure? Determining this will allow you to measure and track technological efficiency. So now we're going to do a quiz. This is about satellite testimony. We mentioned before courtrooms of the future. Well, this is actually a real case where satellite testimony was used in a criminal trial. And this was an example of a couple or a case where it was used because a couple could not be in court, so the court allowed for their testimony in the trial to be done via satellite. And so the question here is, does the use of satellite, and this was a real question, this was what the question that was posed on appeal when the individual that was convicted of robbing a couple that were on vacation in Florida from Buenos Aires, and he robbed them, and charges were brought against them, and they needed their testimony, but they were back home at that point when the trial was going on, and because of health issues and financial issues, they were not able to come back to give live testimony. So their satellite testimony was allowed, and the defendant appealed it, saying that it was a violation of his Sixth Amendment right to be able to confront the witnesses because they were not there at court. So do you think that the use of satellite testimony in criminal trials, do you think that it violates the defendant's Sixth Amendment right to be able to confront his or her accuser? Well, let's see what the answer is. According to the District Court of Appeal in David Harrell versus the State of Florida, satellite testimony does not violate the defendant's Sixth Amendment right because the testimony by satellite is deemed equivalent to live in-court testimony. So this brings in, again, we talked about e-courtrooms. It's going to be, it's kind of ushering in that whole aspect of being able to use satellite testimony, but also addressing any issues that may come up when individuals may actually cite a problem with using e-courtrooms because of issues like this. So if you said no, you were right. Give some explanation. Now, also, some more background information is that live testimony is not considered hearsay, which is what the defendant was purporting in his opposition to the use of satellite testimony of witnesses that ultimately resulted in his conviction. So this is just an example of electronic technology in the legal process and ensuring that issues are addressed, so that, again, I mentioned that there can be those critical errors that occur. Critical error is something that will cause a case to be overturned on appeal, or critical error may actually result in something not even being able to be appealed. So, that's just some things to keep in consideration when using technology in different aspects of the legal process. So with that, I'm going to wrap it up. You can actually send an email if you have any questions. It's actually Rainmakers, RAINMAKERS at Agility, and that's AGILIT as in Tom, Y as in yellow, S as in Sam, V as in Victor, C as in Charlie, S as in Sam.com. Get more information on Six Sigma programs and training on the website. It's sixsigmaforparalegals.com. You can also go to this web link and we'll take you to all of Paralegal Rainmakers courses and different resources that are available. So thank you for your time. I hope this session was helpful and that you learned how to apply Six Sigma, even if it's just on one specific aspect of your job. So thank you again for your time.